So there are a lot of moving parts to understanding this case. And so the thing that we thought we would do today is do a brief PowerPoint. We have both lawyers, non-lawyers on the call. So the lawyers are going to have to take a deep breath and just understand that we're going to slow down a little bit here to understand what the case is about. A couple moving pieces to the case. So we want to make sure that we cover all of those bases. So I'm going to share a screen right now to get up to the PowerPoint. So everybody should be seeing the PowerPoint at this point that we put together for today. And the title for today's PowerPoint is The Case for Wild Rights, Expanding Tribal Sovereignty Through Enforcement of the Rights of Nature and Treaty Rights. And the case that we're talking about today is Monomin versus Minnesota Department of Natural Resources. And again, we wanted to do the PowerPoint today just to provide a foundation for the important conversation that's going to come from Frank and Mari, talking about what the implications of this case are. So again, we wanted to lay the groundwork, the foundation for understanding the case, then move to that important conversation about the implications of the case, what it means, how it can be extended in other places, et cetera. And you'll notice that in the title itself, there are these two big concepts. One is expanding tribal sovereignty through enforcement of the rights of nature. And the second concept is expanding tribal sovereignty through treaty rights. So when Frank and I talk about these issues, it's kind of like the perfect storm between this rights of nature concept, but these treaty rights that the Chippewa hold that are enforced or attempted to be enforced through this particular lawsuit. So just keep in mind those two big topic areas, enforcement of the rights of nature as a tribal sovereignty issue, and enforcement of treaty use rights as an extension of tribal sovereignty. So the case that we're talking about today, again, the formal title is Monomin, which is the Chippewa term for wild rice, versus the Minnesota Department of Natural Resources. So the two quick questions that we asked in the beginning was, why was the case brought? What's the case about? That's what we're going to try to cover during this PowerPoint presentation before I turn it over to Frank and to Mari. So to start with, we talk about the law that's used within this particular lawsuit, the Monomin lawsuit. And we're focused on treaties made between the Chippewa and the United States government. And so for folks who aren't familiar with treaties, treaties are essentially contracts that in this case are signed between the Chippewa tribe and the United States government, in which the Chippewa tribe ceded or gave away certain territory while reserving what are called usufructuary rights or use rights on the property and territory that was ceded. So between 1778 and 1868, there were approximately 370 treaties signed between the United States government and tribes. 44 of those treaties were signed between the Chippewa and the United States government. And just a quotation here on this slide from Article 5 of the 1837 treaty between the Chippewa tribe and the United States government provided that reservation of rights that was taken by the Chippewa in return for that ceding of territory to the United States government. It declares the privilege of hunting, fishing, and gathering the wild rice upon the lands, the rivers, and the lakes included in the territory ceded is guaranteed to the Indians. So that's kind of a standard kind of reservation clause of hunting, fishing, and gathering rights, again, roughly known as use rights or usufructuary rights that were reserved in return for ceding territory to the United States government. And again, we don't want to make it seem that most of these treaties were voluntarily given in terms of the ceded territories. We're just looking at the substance right now, but it's important to understand that none of this happened without pressure from the United States government for various items for that territory to be ceded. And just a quote from one of the Chippewa chiefs that oversaw the 1837 treaty negotiations. And the quote is, "Of all the country that we grant to you, we wish to hold on to a tree where we get our living and to reserve the streams where we drink the waters that give us life." That's from the 1837 treaty journal. again, treaties between the Chippewa and the United States government. In 2018, the White Earth Band's tribal government and the 1855 Treaty Authority, and the 1855 Treaty Authority is an entity that represents about 25,000 Chippewa tribal members who are beneficiaries of the 1855 Treaty. So the 1855 Treaty made between the US government and the Chippewa, the reserved rights to use, hunt, fish, and gather. There are beneficiaries of that reserved use. They are individual tribal Chippewa members, and those members are represented by this entity, the 1855 Treaty Authority. That in 2018, at the end of 2018, the White Earth Band's tribal government and the 1855 Treaty Authority both adopted laws recognizing the rights of wild rice, or Monomin. So legally enforceable rights of wild rice. And we'll talk about rights of nature in a second, but how this fits into that rights of nature concept. So wild rice holding rights, not individual tribal members holding rights. These are in addition to treaty or use rights that those members have, but recognizing that Monomin itself as wild rice, as a cultural staple of the Chippewa people, actually possesses certain legally enforceable rights. And what do the laws say? Well, they declare that wild rice possesses inherent rights to, quote, exist, flourish, regenerate, and evolve, as well as inherent rights to restoration, recovery, and preservation. They declare that Monomin has a right to pure water and freshwater habitat, the right to a healthy climate system, a natural environment free from human-caused global warming impacts and emissions. And it's important to understand the laws give Monomin itself, wild rice itself, in addition to the White Earth Band and tribal members, authority to directly enforce those rights. So again, the laws give Monomin itself the authority to directly enforce those rights. And that's why the name of the case, the lead plaintiff in this particular litigation, is Monomin. So when you look at the court case, the first party listed is Monomin, and it's because the laws recognize that wild rice itself, Monomin itself, has the authority to directly enforce the rights that were established by these laws passed by the White Earth Band and by the 1855 Treaty Authority. So when we talk about Monomin having rights or wild rice having rights, it kind of bends our brains because we're used to talking about rights being held by people or by humans only. But there's been a growth in this area of law known as rights of nature. Basically, the indigenous understanding of nature is not property, but that these rights of nature laws establish legally enforceable rights of nature, species, and ecosystems. So again, an indigenous understanding of nature is not property, and that the laws establish legally enforceable rights of nature, species, and ecosystems. People on this call may be familiar with some of these laws, but rights of nature laws have been adopted by municipal governments in the US, over 30 municipal governments in the US, including places like the city of Pittsburgh and the county of Orange. So Orange County, Florida, last year became the largest municipal government in the United States at 1.5 million people to adopt a rights of nature law protecting various rivers there. Again, those rivers having rights, not necessarily just people having rights, but those rivers having certain rights as well. And of course, municipal governments in Brazil and Canada, most recently the Magpie River in Quebec, received or was recognized as having certain rights by a municipal government and an indigenous community in Canada, becoming the first in Canada to actually have adopted those laws. The rights of nature laws are also embedded in Ecuador's constitution, national laws in Bolivia and Uganda, and in court rulings in Ecuador, Colombia, India, and Bangladesh. People might be familiar with the most recent Ecuadorian constitutional court ruling, which just came out last week, dealing with the Los Cedros Forest Preserve and nullifying some mining permits and concessions that have been granted for that forest preserve as a violation of the rights of nature as recognized by the Ecuadorian Constitution. So a big court case just came down recently, but this is the rights of nature concept, and the Monomin laws passed by the 1855 Treaty Authority and by the White Earth Band reflect this kind of rights of nature legal understanding. So what's the project that's the problem here? In other words, why are we in a lawsuit situation, litigation capacity? It's the Enbridge Line 3 tar sands oil pipeline. And for folks that aren't familiar with the pipeline, it's a pipeline that carries tar sands oil from Alberta to Lake Superior, and it crosses treaty protected lands. In other words, these ceded territory lands between the Chippewa and the US government. It crosses those treaty lands. It's one of the largest crude oil pipelines in the world, carrying up to 915,000 barrels per day of this crude oil, tar sands oil, some of the worst oil for purposes of climate change. First Nations and tribal governments have been fighting for 8 years to stop the project. And these are some of the impacts of Line 3. It's the climate equivalent to the construction of 45 new coal-fired power plants. It affects 389 acres of wild rice and 17 different water bodies that support wild rice. It affects historic and sacred sites on treaty lands. And of course, one of the big issues about the pipeline, not that those others are small, but one of the big issues is that the pipeline has 227 water body crossings. So there's been a lot of concern about aquifer pollution from potential spills from that pipeline. There have been arrests of water protectors. So tribal water protectors have been arrested for enforcing treaty rights and the rights of Monomin against the construction of Line 3. These are tribal members involved in protesting the construction of Line 3 for some of those impact reasons that we just looked at, have been arrested and charged with trespass, even though those protests have been conducted on treaty protected lands. So even though the protests were conducted on territories ceded through the treaties, so therefore treaty protected, and even though the tribal members were involved in protesting the construction of Line 3 to protect Monomin and also to protect hunting and fishing and other use rights guaranteed under the treaty, that they have been arrested and charged with trespass in that capacity of protest. The instant thing that gave birth to this lawsuit, the nexus of this lawsuit, was the dewatering permit that was issued from the State Department of Natural Resources to Enbridge on June 4th of this past year, which permitted Enbridge to use up to 5 billion gallons of water for the construction and testing of the pipeline. So dewatering permit issued from the state Department of Natural Resources, permit to Enbridge to use up to 5 billion, that's billion with a B, 5 billion gallons of water for the construction and testing of the pipeline. So that's kind of the background of treaty rights, the rights of nature laws, the project itself, and the permit which is being challenged under this particular litigation. So the Monomin litigation focused on challenging this particular permit that was issued by the state of Minnesota to allow Enbridge to use up to 5 billion gallons of water for the project. So moving into the case itself, again, the case is captioned. So if you look for the case name, it's called Monomin versus Minnesota Department of Natural Resources. And we're going to talk very briefly before I turn it over to Frank and Tamari about the parties, causes of action, and finally the status of the litigation as it sits today. So the Monomin litigation, who are the plaintiffs, who are the defendants? Well, the plaintiffs, as I mentioned earlier, one of the plaintiffs, the lead plaintiff, is Monomin, so wild rice itself as a plaintiff. The second set of plaintiffs, the White Earth Band of Ojibwe, so the White Earth Band itself, and individual tribal elected officials serve as plaintiffs. So these are tribal elected officials for the White Earth Band. White Earth Band is, of course, sits on the White Earth Reservation as part of the Chippewa tribe in Minnesota. And other plaintiffs include individual tribal members who have been charged with trespass over these Line 3 protests. Again, even though those tribal members were arrested for trespass on treaty ceded territory, and even though they were acting to protect interests protected by those very treaties, have still been arrested and charged with trespass. Who are the defendants? Well, they're the officials with the Minnesota Department of Natural Resources. So in other words, the head people who make decisions within the Department of Natural Resources about the dewatering permit. and also conservation officers. These are the folks that have actually made the arrests for the against the tribal members who were charged with trespass over the Line 3 protests. So plaintiffs, folks seeking to protect treaty rights and the rights of nature, defendants, those entities and individuals who actually make the decisions about issuing the dewatering permit, which is the subject of the challenge in the lawsuit. So there are 6 counts in the complaint. We'll go through this pretty quickly, but just to give people a framework for the complaint. But count 1 asserts that treaty rights override state claims of ownership, basically with respect to the protection of resources within those ceded treaty territories. So count 1 is pretty clean. It's exclusively about treaty rights and how those treaty use rights override these state claims of ownership, i.e. the state claims to issue permits that may interfere with the exercise of those use rights by adversely impacting the resources upon which those use rights are exercised. Count 2 of the 6 counts in the complaint contends that the state has taken treaty recognized use property, in other words, has taken these treaty rights and has not given due process to the tribe or to tribal members as required by the U.S. Constitution in response to taking those treaty rights. So again, count 1, treaty rights override state ability to issue permits that affect those treaty rights. Second, the state has taken those treaty rights and therefore owes compensation or at least has to give due process to the individuals that they're taking those treaty rights from. Count 3, that the state of Minnesota has treated different treaties differently. In other words, they've interpreted different treaties differently as to how the state has to respect or not respect use rights, and therefore equal protection guarantees of the U.S. Constitution have been breached. That basically says that every person has to be treated equally under the eyes of the law. And because the state has treated different treaties differently in terms of their application, especially in light of use rights, that there's a violation of the equal protection guarantee of the U.S. Constitution. Count 4 of the 6 contends that water rights have been seized and taken illegally by the U.S. government, and that those water rights have to be restored. So basically, the taking of this 5 billion gallons of water was done illegally and seized and taken in violation of the treaty guarantees and use rights. Finally, rounding it out, count 5 and 6, that the state has violated religious cultural rights by failing to adequately train their own staff. This is their own staff that are carrying out the arrests and charging with trespass for being on those, protesting on those treaty ceded lands. So that the state has violated religious and cultural rights by carrying out those arrests by not training their staff to respect those treaty rights and therefore not proceed with the arrest. And then count 6 is a pure rights of nature count, that the state has violated the rights of Monomin or wild rice by actually issuing the permit to take 5 billion gallons of water to be taken, because taking that amount of water affects wild rice's ability to exist and flourish as guaranteed by the tribal laws that have been passed. So those are the 6 full counts that are in the Monomin litigation. And the question we always get, well, what are they demanding? What does the lawsuit request? And the primary relief sought is to rescind all water appropriation permits issued for the Line 3 project. And it goes further than that to demand that to live up to the rights contained within the treaties, that the state must establish joint permitting agreements between the state and the Chippewa. So that it's no longer just the state's say about what happens to those resources, i.e. the state just can't keep issuing permits for projects that interfere or infringe upon those treaty rights, but that there has to be a joint permitting agreement between the state and the Chippewa for all future permitting to occur, because that permitting may have an impact on those treaty rights. And then some declarations. So the lawsuit asked the court to declare certain things, which, under litigation practice is known as a declaratory judgment. So you're asking the court to make a judgment and actually make a statement, binding legal statement about the rights of various parties. So in this respect, the litigation asked the court to declare that Monomin has certain rights, and those rights are violated by the water permit. that Minnesota must obtain consent, and it must be real consent, not fake consent, from the Chippewa before state permits can be issued. That Chippewa tribal members possess the right to harvest monoman and protect and save monoman seeds as part of that 1855 treaty that covers ceded territory. And that Chippewa tribal members possess a right of sovereignty and self-determination to actually adopt the laws that they've adopted, and those rights cannot be infringed or violated by governments or business entities like Enbridge. So moving from substance to process, that's the substance of the lawsuit, and this is the process. The lawsuit was filed in tribal court. So again, in tribal court, not in federal district court, not in state district court, but in tribal court. So we're talking about the White Earth Tribal Court on August 4th of this year. So all this, I was joking Frank the other day, it seems like years, but it's actually been not that long. So August 4th, 2021, the lawsuit was filed. On August 12th, the state of Minnesota filed a motion to dismiss. And they filed that motion with the tribal court. Again, we're just in the tribal court. And they asserted that the tribal court lacked jurisdiction to sue the state of Minnesota. They're basically saying, we don't care what the content of the lawsuit is. You can't haul the state into tribal court. So the tribal court lacks jurisdiction to make any ruling over the state. On August 18th, the tribal court denied Minnesota's motion to throw the case out for lack of jurisdiction and declared that, quote, in passing legislation to protect its vital resources, the band must also be able to exercise jurisdiction to carry out that legislative purpose. To hold otherwise reduces tribal sovereignty to a cynical legal fiction. So at that point, the case was filed. State of Minnesota attempted to dismiss it. Tribal court rejected Minnesota's motion to dismiss. What you would expect to happen next would be that the case would move through the tribal court process to a hearing. Evidence would be produced. Witnesses would be deposed, and then there would be a ruling in tribal court. Unfortunately, because of the state of affairs with states being challenged over their authority by tribes in the United States, and the lack of willingness of states generally agree to have their authority reviewed or co-permitted by tribes in the US, that the next thing that happened was that the state of Minnesota actually sued the White Earth Tribal Court. Because of procedural rules we won't get into here, they had to sue the judge as an individual rather than the White Earth Tribal Court as an entity. So they brought a lawsuit against Judge DeGroat, who was the initial judge in the White Earth Tribal Court. And again, the state of Minnesota actually filed a lawsuit against Judge DeGroat, the White Earth Tribal Court, in federal district court. So they hauled the tribe from tribal court to federal court and asked the federal court judge to block the White Earth Tribal Court from ruling in the case. So again, this was an effort to block the tribal court from moving forward with the case. On September 3rd, the federal district court denied the state's request, denied the state of Minnesota's request to throw the case out, dismissing the state's lawsuit and holding that the tribe couldn't be sued in federal court over the matter. So basically not looking at substance, but holding that the state couldn't haul the tribe into federal court to actually try to stop it from proceeding with the case. Instead of just washing their hands of the matter and watching the tribal court move forward with the case at that point, on September 10th, the state filed an emergency appeal. So it's the state of Minnesota filing an emergency appeal, appealing the district court's denial of its motion to dismiss the lawsuit to the 8th Circuit Court of Appeals. And for the non-lawyers, obviously this looks like probably a complicated maze, but the 8th Circuit Court of Appeals has appellate authority over the federal district court. So this was the state of Minnesota arguing that the federal district court was wrong and that the 8th Circuit Court of Appeals had to fix the situation. And they asked the 8th Circuit Court of Appeals again to block the tribal court from moving forward to make a decision in the case. On September 21st, the 8th Circuit Court of Appeals denied the state of Minnesota's emergency request to overturn the district court. But by law, because it's an appeal, they have to hear the case. And a December hearing date of December 16th has been set. to actually hear that appeal. So again, 8th Circuit denied the state's emergency request to move it quickly and instead set a December hearing date for a decision that would be issued sometime in 2022. So what was happening in White Earth Tribal Court as all this was happening in the Federal District Court and the 8th Circuit Court of Appeals? Well, the original tribal court judge had to recuse himself, Judge DeGroat, due to the filing of the Federal District Court lawsuit because it created a conflict of interest. He was now a defendant in the federal court lawsuit while presiding over the case in tribal court. He recused himself. A new judge was then assigned to the case. And the new judge assigned to the case reiterated that the tribal court possessed jurisdiction to hear the case. So again, new judge coming in affirmed or reiterated that the original tribal court's decision, tribal court judge's decision, that the tribal court had jurisdiction to hear this case and make a ruling on it was the right one, and reiterated that the original tribal court judge's decision. On September 13th, the state of Minnesota then filed an appeal of the tribal court's ruling to the White Earth Court of Appeals. So again, we're back in tribal court now. The case in the 8th Circuit Court of Appeals kind of frozen until December 16th. The case that the state of Minnesota filed against the tribe in federal court. We're back in tribal court now, and the state of Minnesota filed an appeal of the lower tribal court's decision that it had jurisdiction over the case up to the White Earth Court of Appeals and urged it to find that the tribal court lacked jurisdiction to hear the case. So asked the tribal court, the White Earth Court of Appeals, to reverse the ruling of the judges within the White Earth Tribal Court that there was jurisdiction to hear the case. And by law, by rule, the case within the tribal court is currently stayed until the appellate court rules. So there's an automatic stay that was issued within the tribal court until the appellate court rules. So again, complicated maze, a lot of moving parts. Suffice it to say, the state of Minnesota was so afraid of the tribal court ruling that they not only went to federal court and sued the tribe to stop it from ruling in the case, but also went back to the tribal court to try to get the tribal court's ruling overturned to make sure that the tribal court couldn't hear the case as well. So I think that gives some degree of emergency to the state of Minnesota in terms of the steps that they've taken to try to stop the tribal court from actually hearing this case and deciding it. So with that, that's the background. Again, the law itself, which is treaty rights, rights of nature, the project, which is Enbridge's Line 3, the permit that was issued to expedite Line 3, dealing with that 5 billion gallons of water, that permit that was issued by the state of Minnesota, and then the case itself, which attempts to stop the dewatering permit, to nullify it on the basis that it and the project itself violates the rights of nature and treaty use rights as guaranteed to Chippewa tribal members. And that's where we sit today in terms of the posture of the case.